Etie for my minda muna masi and fambra your channel you message set notification button or button on now subscribe to the any update to be on Sabeka no ashe ama bibia aye kama e branch o mengi bre ni nkotie nsem kakra ekos
waiting to receive the written address, as it were, the final arguments of the respondent, the Chief Justice's lawyers, to factor it in their decision making, regardless of the fact that they didn't meet the deadline. But a day before, as Aikutu says, they wrote to the committee to say, we are unable to meet the deadline. Can you give us extra time? And we all do this in the courtroom, right?
Yes, my brother. Thank you very much. But I want to confirm one thing. Where was the committee given a timeline within which to operate? Can we confirm that?
We don't know about that, and generally Article 146 does not provide timelines. Perhaps that is the reason when you were passing the Special Office of Special Prosecutor Act in 2017, you put in there that there should be timelines, so everything is time bound.
So, in the absence of timelines, what was the committee in a hurry for? Why the rush? Particularly because you have two other petitions, so to speak, our address holders pending before you. Why? Who was putting pressure on you to achieve what? When you are dealing with a matter as important as the removal of the Chief Justice of the Republic of the land. When were you in a hurry to present your report on just one of the petitions, right? Which, in your view, will then dispose of all the matters and will make other petitions redundant? Wouldn't you have taken your time to receive the address or submission of the Chief Justice? Doesn't fairness dictate it? I thought that this is not a commission of inquiry, right? It's also not, even though you are using CI 47, even with CI 47, Thompson, how many times doesn't the court adjourn just to take our addresses? The court adjourns on many occasions. Sometimes, even when the court has fixed the date for parties to file their addresses, you can come in with an application that may impact the filing of the address. And so the court, in hearing the application or having disposed of the application, will give a new date to the address. And so even under the CI 47, there is always enough room for the court to entertain such request for adjournment to receive or to file addresses.
But that's obviously discretionary, right?
Yes, but I would think that when you are dealing with a matter of this nature, you should be predisposed to a lot of laxity to accommodate, the Chief Justice, particularly given the sensitivity of the matter that we were dealing with, the sensitive nature of the matter which we were dealing with.
You think 6 months, we've been at it for almost 6 months now, is it? You think that's too short when you say they are in a hurry?
I haven't said that the time is too short or too long. I'm saying that in the specific reference to the reception of the address, if a request that comes and is unreasonable, particularly given the feedback that we have received from Mr. Aikutu, right? To rush to file, to present your report, for me, is very, very, very unfortunate.
What would you say to those who say, well, if you take the issue or your case as seriously as you ought to, you shouldn't be found wanting, to meet a deadline. You should actually work to beat the deadline.
Rather, given the gamut of evidence that have been disclosed to have been produced before the committee, given the number of witnesses. I think that it will be, it's not something which is not expected. It's expected that lawyers or barristers will always ask for extension of time in the circumstance of this nature, particularly also given the grievous nature of the matter at hand. Look, this is a matter involving the removal of the Chief Justice.
In fact, the committee said that they received about 10,000 pages of documentary exhibits from both sides.
So, if somebody asks for extension of time, I don't think it is out of place.
But does it also matter, or it doesn't matter to you, that when you file such addresses, according to law, the address is actually not mandatory, and whatever you put in the address is not also binding on the judges?
It aids the court in coming to its decision.
That's right.
And if it was not necessary, you would have scrapped it. It is put there to tell you that if you don't file, the court can go ahead to make a decision. However, given the controversial nature of this matter, we want to put it beyond reproach, beyond blemish. As it stands now, it's one of the things that we are going to point to as contributing to the injustice or the unfairness of the process. Look, my brother, the other issue that you raised pertaining to why the committee presented a report on one of the petitions instead of completing with the hearing in respect of the two other petitions. In my view, the failure to do that has not only rendered an unfairness or injustice to the parties that filed the petition, but the Chief Justice, because those allegations will continue to hang around their neck without having the opportunity to prove that they were not true. And so this approach by the committee has also unfairly versed the...
So a very quick one before I go to my member Bonsu. Yes, they had 13 witnesses for one side, 12 witnesses for the other side. They had 10,000 documentary exhibits all together, which makes it a lot. I can't imagine myself as a lawyer having to go through such load to write, an address. But some will argue that sometimes you and I know by our practice, as the case is going on, you should be gathering your address. You will be getting each of the record of proceedings. After the close of each day, you get a record, and then you start writing bit by bit and so on and so forth. But my substantive question is this: how do these two events, not waiting or granting an extension of time to receive the address, to use it to factor into their decision, and also presenting a separate decision, how do these change call them the admitted facts? So that, for example, on the travel expense, the Chief Justice does not deny that this happened, that she took the money, that she went with the husband, that she went with the daughter, and that per diems were paid, and that she retired unimpressed of 6,000 plus or so. If the decision is that this was wrong, this was unlawful, this was unconstitutional, how does giving extra time or presenting a composite report change it?
Whether or not it is wrong would also is one level, and it is distinct from whether or not it meets the constitutional threshold for the removal of the CJ under Article 1461 of the Constitution. They are two distinct. We need to appreciate that not every error or, if you like, offense or happening may meet that constitutional threshold. Otherwise, every flimsy thing may lead to the removal of the Chief Justice. For Reverend, you see, this whole matter, we are talking about, I hear Oliver make reference to petition. This is where the error started from. The error started from the wrong foundation. The president receives a petition.
Okay, Nana, please pardon me. Please pardon me. Hold on. I want to do something. No, hold on. We'll go there shortly. Mami, I want you to bring your view on these two preliminary issues as after the report has been presented. Whether the not waiting for or giving an extension of time for them to file their address, and also presenting a separate report for Daniel Ofori's petition, which actually contained the most charges. What difference does it make, and how would you say that doesn't make things tidier?
Thank you, Samson. I think I want to start by saying that in pure terms of technical effect, the committee did nothing wrong. It doesn't affect the legality of it in any way, that they did not grant an extension, or that they did not send a consolidated report, because they are separate petitions which require separate conclusions. And while it may have been nice to have had all three together, there is nothing by way of error in them not choosing to do so. However, I'm going to have to agree with Nana Ajayboa for that. The refusal to grant the extension was neither necessary nor prudent. I think, given the gravity of the situation and the gravity of its outcome, it was important for there to be no residual doubts around it to the extent possible, because as Honorable Hussein pointed out, we are always in a new space with untried constitutional provisions. So the errors are bound to be laid. But there are avoidable errors. And I think granting them, we've been 6 months down this road. I think one more week would not have hurt. That said, I don't think it actually invalidates anything. I just think it creates an unnecessary, if you like, noise around the committee's work, which it could have spared itself simply by giving them a week. As to the decision to send them individually, if I send a petition, I'm not quite sure why I should have to wait till somebody else's petition has been heard before I know what the outcome of mine is. So I can't fault that. The president's decision to act on the recommendations of that particular petition as opposed to wait for the rest, again, it was a choice, but he was bound by the recommendation of that particular petition. So whether he waited or he didn't wait, he would have ended up doing the same thing because he was bound. He is bound by the recommendations. It's not a discretionary choice to accept, or he can't issue a white paper saying he thinks they've done a good job, but he's going to question her and let her go or whatever. He was bound, and therefore the decision to act, I think people are entitled to their opinions whether he should have waited or not. Was it necessary for him to wait? I don't think so. The process, and I do take Nana Ajayboa's point that the charges in the other petitions remain unresolved, and so she hasn't had a chance to prove her innocence. However, those petitions are supposed to be secret anyway. So if everybody had been doing their part in this journey, nobody leaking documents, and everybody respecting the constitutional provision on secrecy, then the unresolved nature of the petitions should not really affect the reputation of the respondent. The problem is that people haven't. But if everybody had done so, it should not matter. As a matter of public funds, this committee is sitting on public funds. They have heard one petition. They have heard it to its end. They have come to a conclusion on it. Their conclusion leads to a single position in law. They have sent the report on to the president. I'm not sure that the cost of public funds to continue the process, given that its conclusion was now set in stone once the committee's recommendations in Daniel Ofori were made, is justified. I do admit that if they had finished, at least we'd have a historical record. But I don't know that I would say that would justify the cost to the public purse. So
you are saying the chairman of the committee, Justice Gabriel Scott Pwamang, ended his speech to the president by saying, accordingly, we shall be reporting on the second and third petitions in due time. We are saying that this has become obtuse, we can't get to them anymore, it's waste of public funds if we go to them.
I think we can decide to carry on, but as Oliver points out, you are dealing with the removal of a chief justice, a petition to remove a chief justice who is no longer chief justice. So supposing we go through the process and we get to the end and the recommendation is that she should be removed, what action will the president take now? So then it will be a long and expensive process, so we know that she should have been removed 3 times, or she should have been removed only once, or twice she would have been removed. But so I'm not sure that there's any value to continuing it. Right. I think Justice Pwamang was correct to state that they would, when they finish the petition 1, they have petition 2, they were charged to listen to 3 petitions because they don't remove the Chief Justice. That's not the committee's job. The committee's job is to hear the petitions and decide whether they meet the constitutional thresholds for removal and recommend same. That's their job in case of each petition. So supposing the president had decided to wait, the committee could carry on with its work.
There are a number of cases, suits that have been mounted on the back of this, including as pursued by the Chief Justice herself. And there's been commentary from left, right, center, including the Bar Council in England. Do you suspect that this was to preempt anything that could, have come out of any of those suits that are still pending, that they could have scuttled the committee's work, and that's why the committee decided to run past with the first one?
Thompson, I'm not a political commentator. I'm going to say that in constitutional matters, suspicions are irrelevant. Yeah. So I don't suspect. Yeah. I deal with the constitutional law and the content.
And the Supreme Court says that a law constitutes proof.
It cannot constitute proof or law. So I'm going to decline to speculate on the matter of why. The president, I will say, was completely within his rights to act when he chose to do so.